Good morning, everyone. My name is Anna Siefken, and I'm the Executive Director for the Scott Institute for Energy Innovation at Carnegie Mellon University. Thank you very much for joining us this morning for a special webinar focused on IP and patents, specifically for startups. We have a large group of you on the call today, and we have a set of very distinguished guests. So I'm going to jump right into the content. There is an opportunity for you to ask questions, so please use the question box. A little bit easier than the chat function. Use the question box, and we'll make sure to get to those. Before we start, though, I want to make sure that we thank all of our frontline workers. We're in a very interesting time right now with multiple crises layering out one on top of another. There's a lot of disruption that's happening all around us. We just want to remember all of the folks who are deeply engaged in those important conversations right now, even as we're talking about energy systems, which are critical, but there are other things as well. So we want to just welcome all of you here for this, this talk this morning. So understanding intellectual property and patent processes when building a startup can be uniquely challenging for inventors. So the Scott Institute is a power connector with the Department of Energy's American-made prizes. And so through that, we actually are offering this special webinar on this important topic for startups, startup teams, students, and researchers. So today we're going to hear from a couple of experts specific to IP. So before I get into those introductions, I want to tell you a little bit about the Scott Institute. So the Scott Institute is focused on creating collaborative research, strategic partners, engaging in public policy and outreach, entrepreneurship, and education for students. So we serve as a hub for energy-related topics at Carnegie Mellon, and we invite any and all of you to participate in our programming. So as I mentioned, we're a part of the American-made prizes, in fact, two of them in particular. So the American-made Solar Prize is a $3 million competition that's designed to energize solar manufacturing through a series of contests and the development of diverse, powerful support network. So as a part of that, Babst Calland is a connector, which is why we're offering this special opportunity this morning. I do want to let you know there's a brand new prize called the Geothermal Manufacturing Prize, which is designed to help sort of solve the issues associated with harsh geothermal environments through, again, manufacturing in the United States. There are a couple of upcoming deadlines that are important for the Solar Prize, AMSP. We have a contest for Go, which is a final round in July of 2020, and we'll be announcing those winners. The new competition, which has just opened, has its first deadline on August 26th. So if you're interested in hearing more about one of these prizes, please contact me or anyone on the Scott team. And there's also a web address at the bottom where you can find out specifically about some of the manufacturing related opportunities. This is a special session today that's specifically for startups and investors, but we do want to let you know that we have an ongoing webinar series. There are sessions about twice a month on Thursdays. So the next one that's coming up is on utility planning. We have the leadership from 3 different utilities in the Pittsburgh region talking about planning. We've added a special session that's coming up on July 9th about energy access and equity. So really looking at how we can think in the energy sector about those important topics. We have a session on investments that's coming up with 5 investor leaders. So again, that's a great one for those of you that are startups. It's on July 23rd. On the 6th of August, we're talking about transportation energy, particularly in last mile and mobility. And finally, on August 20th, Jay Whitacre, who's on this call today, will be hosting a special session on batteries and storage. So all of that information is available on our website. So I want to say a special thank you before I get to those introductions to both the American-Made Challenges for supporting us through this Power Connector program and to Babst Calland for participating today as a connector. So these are our distinguished guests today. We have Jay Whitacre, who's the director of the Scott Institute at Carnegie Mellon. And we have Ronald and Justine Kasznica, both from Babst Calland. And I'm going to have them introduce themselves today, starting with Justine, then Carl, and then Jay, so that we can hear more about their specific interests and efforts with entrepreneurs. So Justine.
Good morning, everyone. It's great to be here. Thank you, Anna, for those kind words of introduction and for letting us know about the Scott Institute and the important work that you're doing there. I am a shareholder at Babst Calland, a Pittsburgh headquartered energy and environmental law firm. I am the head of our emerging technology group, as well as the head of our mobility regulatory practice. Carl and I joined the firm about 2 years ago with the goal of building up and supporting the emerging technology capabilities of the firm. My background is as a corporate commercial and technology lawyer. I've spent about 15 years working as a corporate lawyer supporting the life cycle of early stage companies in the technology field. My practice in Pittsburgh revolves largely around advanced technologies, including robotics, hardware, software, embedded systems, and the like. Before coming to Babst and in the middle of my practicing law, I ran an innovation institute out of the University of Pittsburgh School of Law, focusing on supporting entrepreneurs in this region and across the country in understanding how to go from idea to growth stage and commercialize and generate value for companies. I am dedicated to supporting innovation, ecosystems, and entrepreneurial activity, and I'm fortunate enough to be at a firm that is building and expanding our practice in that area.
Fantastic. Carl?
Thank you, Anna. I appreciate you having us on to talk today. So my name is Ronald. I'm a shareholder in the emerging technologies practice here at Babst Calland. I'm an engineer by training. I've been helping entrepreneurs, startups, mid-stage companies for the past 20 years in protecting their intellectual property. I've worked in-house for a couple of different companies. One was a medical device company that also did robotics. And another one was a consumer electronics company, I guess you'd call it, in the baby gear space. Currently I sit on 2 different screening committees and due diligence committees for 2 different angel groups here. So angel groups we may get into later are high net worth individuals who invest in startup companies. And then finally, I'm on the climate change committee here at Babst Calland to sort of keep track of innovations and company responses to what's going on in the environment. So thank you.
Of course. And Jay?
Hi there, I'm Jay Whitacre. I'm the director of the Scott Institute at CMU. So I'm here partly in that capacity. Welcome to everyone who's tuned in. It's great to have such a large audience. We really count on, in these days, on folks tuning in this way to still get our message out and to have some impact. So it's fabulous to have you all. But I'm here also as an entrepreneur, an energy entrepreneur in particular. I was at the Jet Propulsion Laboratory for 7 years and then moved out here in 2007 to take a professorship at CMU. And had an interesting discovery in my lab that led to the founding of a company based on a new battery chemistry. And we actually built a factory here in Pennsylvania, raised over $200 million, and saw the full arc. Founding, growth, hiring, manufacturing, and eventually sale. It was at a loss. It was a bankruptcy, a loss, though the company persists mainly in China. And so having been through that arc once, and prior to that, I did a lot of technical diligence for other investors like venture capitalists and so forth. I've also either authored or co-authored, I think I'm at 40 some odd patents. And I also do a lot of expert witness work for intellectual property law firms who are one way or another going through cases at the federal level like the ITC. So I have sort of this broad sort of experience around entrepreneurship and intellectual property. And the idea was for me to pepper in, I think, some of my own observations and experiences to sort of give a boots on the ground observations and anecdotal stories around what Justine and Carl are going to be talking about.
Thank you. Thanks all 3 of you. So as we sort of navigate through this new Zoom experience, I just want to let the speakers know that while I'm sharing our next few slides, I'm not able to see the questions that come in. So I've just realized that. So we're going to go through these, but just know, please put those questions in at the end of this short presentation. I'll be able to suddenly see all of your questions at once. So I apologize that I won't be peppering them in. I think I'm just going to sit here on mute while you guys go through this. So thank you so much, Justine and Carl.
Thank you, Anna. So when Carl and I sat down and talked with Anna and Jay about how to approach this, obviously the field of intellectual property is incredibly broad, can be very detailed from a legal perspective. And since we didn't have a strong sense of knowing who our audience is and how sophisticated the approach towards intellectual property or the background knowledge of IP, we decided that we would essentially take a little bit of a step back and talk about intellectual property from the perspective of a company's life cycle. And so we start with formation. We understand from the Solar Prize and NREL's work that a number of our audience members today are entrepreneurs who have either just formed a company or an entity or are in the process of doing that now. If there's anything to take away from this presentation, it is that it is never too early to start thinking about intellectual property, particularly when you are building a technology company. We do a lot of work with forming early stage companies in the technology space. And one of the initial conversations that we'll have with entrepreneurs is a conversation around intellectual property and in particular diligence. So when you have an early stage company, typically you have several founders that come together with an idea on how to create a company that will offer a product or a service or a technology that will provide innovation and be commercialized for a mass market. One of the first topics to think about is, well, what intellectual property is being contributed to the company on day one? Perhaps some of the founders are professors, students, perhaps they are researchers who have already developed some amount of technology, and that technology is intended to be contributed to the company as a starting point for revenue growth and business development. The critical pieces that we think about when we form companies is making sure that the company actually owns the IP that it says or thinks it owns, so that it can then leverage that intellectual property for value. To do that, an early stage assessment of the intellectual property that is developed is critical, as well as the ownership of that intellectual property. Time and time again, we have early stage founders who may be coming from an employer or another company that may even be competitive with the company that the founder is trying to build. Oftentimes, we have founders that are university professors or students who are intending to bring technology that they've been working on in university labs, for example, to the company. One of the critical steps that lawyers help companies do in this IP diligence phase during formation is an assessment of what technologies are present and what is being contributed, and then making sure that the intellectual property is assigned to the new entity, so that that new entity, let's call it NewCo LLC or Inc., can show and certify and represent and warrant to the fact that it actually owns the intellectual property that is going to be the value add for that company. As a quick illustration, a typical pitfall that we run into time and time again is a early stage company that fails to provide its founders with a proprietary invention assignment agreement that assigns that intellectual property to the company. Things are going great. Year later, 2 years later, 5 years later, maybe that honeymoon founder period is over for the entrepreneurs, and one founder decides to walk. And if that founder has not signed its intellectual property assignment agreements, confidentiality agreements, and restricted covenant agreements early on, that founder can walk away from the company still owning that intellectual property. And guess what? The value of the company that thought it owned that intellectual property is suddenly in question, causing us lawyers to have a lot of headache and work to work with the company to try to clean that up. And because that individual wasn't given the right documentation at the outset, many times those individuals now have leverage to negotiate and obtain more value for their IP that they otherwise would have had they had things been done properly. So that's just a common pitfall that we typically see. But another pitfall that we see is founders not necessarily doing a deep dive into an assessment of who owns the IP that they're looking to assign. Perhaps they don't actually have the rights to assign the intellectual property. And this is where questions around ownership become very important. And any founder is well advised to take a look at pre-existing employment agreements, or if you are tied to a research lab or a university, making sure that invention disclosures have been properly filed, that an assessment has been done whether intellectual property that will be assigned into a company is actually owned by the university instead of the individual looking to assign. And depending on the answer to those questions, your legal team will take different routes for helping to free up or unencumber that intellectual property so that it can be either properly assigned or properly licensed to the company so that the company has absolute comfort and confidence in the rights to that IP. Why is this important? Well, primarily because in the life cycle of technology companies, the initial holy grail is financing. You'll hear from Jay talking about his experiences with venture and angel investment financing. One of the first things that investors do is they'll conduct their own due diligence. And one of the things that they are critically interested in making sure is squeaky clean is an intellectual property assessment and the ability for the company to commercialize intellectual property in an unencumbered way. We also, another pitfall that we want to touch on very briefly at the outset in the formation stage, especially since a lot of startups end up, technology startups have their origins at universities, are publication pitfalls. Carl, do you want to say a few words about that?
Sure, yeah, so specifically to sort of technologists or engineers or scientists within university, a lot of times the pressure is to publish as soon as possible. And so that can be anathema to owning the IP because for patents in particular, if you publish it, you've told the world how to do something, and that can destroy novelty. And as we'll discuss later, novelty is one of the key legs of the three-legged stool for patentability. So we really need to be careful. Often, a couple of times I've had entrepreneurs, I've had folks in university call me and say, hey, we're presenting a poster next weekend at this trade show. Do we need to do anything? And of course, that's a mad scramble because we need to evaluate whether or not we think it's protectable, that what they have is protectable. Backing up real quickly on the IP diligence, one of the practical ways that I've seen entrepreneurs and what I advise entrepreneurs to do when they're evaluating whether or not they can own something is to create a spreadsheet and use publicly available database such as Google Patents, for example, that has natural language search to take a look at what else is out there and try and identify other patents and other publications that are similar. Put that in a spreadsheet, make a couple of notes with your evaluation of it. That will really help your patent attorney if it comes time to go ahead and prepare a patent application or decide whether or not to keep something trade secret.
Can I jump in here with a couple of anecdotal stories based on these two things, guys, real quick?
Sure.
First, on the stuff that Justine was talking about, it's absolutely true that when you go to raise money, and some of the things I'm going to say might be somewhat controversial, but they're certainly my experience. Thing one is investors don't want to invest in companies that don't have formal intellectual property. It is absolutely seen as a key box to check, and it ought to map directly to your product. Some folks, some entrepreneurs, I think, take this to heart. And, I was, after sort of being on the technical diligence side with venture capitalists for 5 years before doing my own company, I went through the measures of actually, creating 3 or 4 different patents, a couple of which I was like, these may not be useful right now, but I'm going to have a patent portfolio. And I'm going to be able to say that I have a patent portfolio. And the company's going to grow into these. So don't be shy creating intellectual property that is forward-reaching, that is, something that shows next generation development. Another question that your investors are going to ask is what's next? And you can point to, hey, here's 2 patents that I have. We haven't proven everything out yet. I've got proof of concept on the bench level. It's not reduced to full manufacturing practice, but it's real. Those kinds of stories are incredibly compelling when you're raising money. Remember, your customers as an early stage, an entrepreneur, your customers are every bit as much the investors as they are people who will eventually buy your product. And part of what they consume is your intellectual property portfolio. So that's one thing. And the second part, Carl, what was the first topic you talked about? I didn't take notes. I apologize, but I have
The first part was publication, like maybe a poster.
Oh yeah, this is a huge point of friction too. For sure, as a professor, I was non-tenured at the time, or untenured yet at the time that I sort of had some of the early discoveries, and I really wanted to publish this, but my investors were like, no, you can't publish this, don't do it yet. And so it was a lot about timing and a lot about managing the intellectual property process and understanding what was available when. Eventually, your patents will be published at some point, if they're, unless you, do a non-published clause, and that's only for U.S., not international patents. So you can time your release of your paper around then. And the other thing I was wondering about from Justine and Carl's perspective are the use of provisional patents. One of the things that I do and I advise others to do if I have something really hot is to immediately get a provisional file that covers as broadly as possible all things. And that sort of gives me a ticket to talk about this with some protection off the top. Am I wrong in thinking that, or is that a good piece of advice?
No, I do think that's a good piece of advice. The only caveat I would have to that, first of all, yes, if you're going to present something next Friday, that's what we're going to do. We're going to put a provisional together, and we're going to get as much information about enabling the invention, teaching somebody how to do what you're doing. Because after all, as we'll discuss, a patent or a provisional patent is supposed to be a teaching tool, right? But what you want to do is get a patent on file so that you have an early priority date, right? You've got something on file, so then you can talk about it without worrying about destroying novelty. The caveat that I had was just that you need to make sure it sufficiently enables your invention, or else you won't be able to rely upon it later if you're successful and if there's a lawsuit, right? So, if you take a snapshot of it, and submit a picture, and then you just write down a couple of things and submit it as a provisional, that may not be sufficient. So you just really need to take a critical eye at your provisional without going overboard, but yeah.
Yeah, that's why I was explicit to say broad and sort of encompassing, right? You want to make sure you capture not just the specifics, but the generalities of what you're doing, and also project out to what you think it's going to look like. Okay.
And just two comments on the commercialization narrative. So when you're a young company, it's all about financing in the door, and a provisional is going to cost generally a lot less than a full-blown application. So a young company may be able to afford a provisional and have the magic words patent pending in their slide decks when they're talking to investors who are looking, maybe they understand that you're an early stage company, but are looking to see that you're sophisticated enough to be laying the groundwork for a formal patent portfolio in the future. And that patent pending language is critical to establishing that. In fact, I've seen companies that have been able to recoup at an early stage financing a lot more value in terms of the pre-money valuation of the initial investment, simply because they've thought through a pathway and a strategy towards a formal IP portfolio. This is obviously going to be industry dependent, but in the renewable industry space, as with the spaces that we work in, advanced technologies, patent portfolios are almost critical to establishing value.
Absolutely, and just from a dollars and cents perspective, provisionals cost hundreds of dollars to file, and the value they add to your company is orders of magnitude greater than that. So it's really a no-brainer.
Sure. So let's go ahead and talk a little bit more about the considerations involved with patents versus trade secrets, because when you have a new way of doing something, not necessarily a new device, but a new process or a new method, there's this inherent tension. Should we keep it to ourselves and not tell anybody about what we're doing and how we do it? Or should we tell the world, right? Keeping it to yourself is a trade secret. Telling the world is a patent, broadly. So, if it's a trade secret, you really need to take measures internally to keep it secret, right? So only key individuals within your organization can know about it. You must have employment contracts that bind those employees and keep them from disclosing this information to others. One of the benefits of trade secret is that potentially it could last forever. So most people know about the formula for Coca-Cola being a trade secret. Thomas's English muffins, the way they create the nooks and crannies, that's also a trade secret, surprisingly. So a couple of examples. On the other hand, if you want to go the patent route. And as Jay has mentioned, investors really do like to check that box and see that you filed for a patent. You have this notion of provisional versus non-provisional. A provisional patent application will never be examined by anybody and will never be seen by anybody unless you introduce it some way down the line in the context of litigation. And let's hope nobody ever gets there. Provisional is really just, making sure that you have a filing date and that you've disclosed what it is you're doing. And then you have a year to continue to commercialize, to talk about it, to develop the technology. And then within that year, you're required to file the full-blown patent application, which we in the trade call a non-provisional patent application. And then if you want international protection, you have a year from your earliest filing date, whether that was a provisional filing or a full-blown patent application, to then try and go overseas. You can use the Patent Cooperation Treaty. There's tons of ways to go directly into certain countries. And I think that's probably beyond the scope of this presentation, but just know that the key deadlines are a year from your first filing. All right. Yeah, Jay, did you have anything you wanted to say there?
No, just for those out there who are truly new to this, you have, if you file a provisional, you have exactly a year to file a non-provisional no matter what as well. So the PCT process is a year subsequent, and also the provisional process gives you essentially a year to do things. There's some question too, if you file a US provisional patent and then present or publish something after that, and then file a PCT application after that, is there a chance that that paper you published is prior art under PCT, or is it protected by the US provisional process?
No, the PCT process does allow you to use the provisional to protect you. So
I had forgotten that detail.
Yeah. That was actually a concession when we were doing the General Agreement on Tariffs and Trade back in 1995, way back when. So I did want to say also that if your provisional expires and you don't file a non-provisional, you could file that same provisional again. You would just lose that early priority date. And so the impact of that would be that any other prior art, anybody else's publication in that time period could be used against you to say that your disclosure is obvious or not new. All right, so you can file a provisional, and if it expires, no big deal. Nobody saw it. You just lose that early date. And then your new filing date, if you filed another one, would be your earliest date. Because after all, we are now a first to file country like the rest of the world, which means that your rights start and all prior art is judged against the date that you filed your patent application. It used to be that America was first to invent. So I could file something, and then if I could show engineering notebooks back 3 years back, so long as I took diligent steps to reduce the invention to practice, I would get that really early date. Those days are gone. It's really is a race to the courthouse, so to speak, now. So let's back up for a second and talk about what a patent is. It's a teaching document. If you take away nothing else from this discussion, I want you to take away that a patent is, in essence, teaching somebody how to do what it is that your invention is. It's a government-issued right for a limited time. A limited time is 20 years from the date of filing. To keep others, it's a limited monopoly, right? So you're excluding others from making, using, selling, or importing that which is disclosed in your patent application. That's the bargain for exchange. You teach the world how to do something, and you get a limited monopoly. And you can license that, you can practice it, you can keep it to yourself, but that's sort of what a patent is. The next slide, please. Thank you. So requirements for patent, for utility patents, and these are patents that protect new devices or new processes. The really valuable things are how to do stuff. It must be new. It can't have been disclosed anywhere, and that dovetails with our conversation about publication. So you can't have published it before you file for a patent application. It has to be useful, which is pretty easy, right? Anything that you would file for would be, it would have utility, it would be useful. And finally, it has to be non-obvious. And there's a lot of litigation and hand-wringing in the industry about what obviousness is. The standard definition is this fictional character we create in the law, which is it's a person having ordinary skill in the art. So your average engineer, but that average engineer of average ingenuity is charged with knowing about every piece of prior art that's out there. They're supposed to know all the other patents that have been published, all the publications, all the journal articles. Knowing all of that, if this person of average ingenuity, would they think it would be obvious to do what you've done? That's kind of the challenge that we're undertaking with this obviousness question. If you have all three of these elements, this three-legged stool, then you are eligible for a patent. Unless, of course, there's some reason it's statutorily ineligible, or courts have said it's ineligible. Things that are ineligible are, for example, ways of managing risk in money markets. Things that the courts have said, you know what, that's really a field of human endeavor that we can do in our mind, and so we're not going to allow you to have any sort of patent protection on that. And that's actually a hot issue as well. It's called Section 101 of the Patent Act. And as of maybe 10 years ago, it's been all patent attorneys have been talking about. But again, takeaway, new, useful, non-obvious, you should be able to get a patent. And so contrasting that with trade secrets, trade secret really is any information that nobody knows about that gives you a competitive advantage. So that information could be a method of making Thomas's English muffins. It could be a formula. It could be a method of creating steel, right? Or curing steel in a certain way that gives it great properties. So long as you keep it secret with employment and confidentiality agreements, limit disclosure to those within the company who actually need to know, that secret can last forever. But it's difficult to accept investment because investors are always concerned about rogue employees taking this information and going somewhere else. To the extent they do, you really can't do much about it, right? If the secret's out, the secret's out. You can sue a person who left for violation of their confidentiality obligations because you'd have some sort of non-disclosure agreement with them or confidentiality agreement, but you would still have the issue that it's no longer secret. So that's sort of the upside is it lasts forever. The downside is a rogue employee can destroy it.
Just a quick point. So with respect to a particular invention, trade secrets and patents are mutually exclusive because the patent is ultimately going to publish to the world your invention. The trade secret is going to keep it secret. However, when you're talking about a broader intellectual property portfolio for a company, most technology companies will have some combination of patents and trade secrets. So those things that are critical to a company's competitive advantage that cannot be patented or have failed the patentability analysis can still be protected as a trade secret and making a robust IP portfolio protected. The other point that I would like to mention is everyone's familiar pretty much with NDAs, your classic confidentiality non-disclosure agreements that you sign with prospective partners, prospective customers, employees, etc. If you are going to be disclosing trade secrets in the context of your business relationship with a third party, and you have a classic NDA that has a set date, which most of them do, for the non-disclosure period, make sure to carve out your trade secrets from that, because if you have an NDA that lasts 3 years and then it's done, at that point, if you've essentially shared your trade secrets with that other party, that party is free to disclose those trade secrets after that 3-year mark, and therefore potentially blowing that trade secret status. It's really important to look at every confidentiality agreement that is entered into if there's going to be trade secrets that are divulged.
And I'll just jump in really quick here too, that from my perspective, the key thing with what is a trade secret, how do I decide to do it, it's degree of how easy would it be to reverse engineer? If someone could take your thing, your product, whatever it is, and by disassembling it one way or another, or somehow cracking the code or whatever it is that protects what's inside of it. And if they would be able to figure out how to make another one, all the attributes that allow them to figure those things out, you should seek to patent. But in my world, battery chemistry stuff, chemical processes in general are often, you can't really, even though you have a final product, you can't really tell how it was made. And some key trade secrets are things like order of additions when you're mixing things, or how did you mix it? How did you heat it? How did you, as Carl said, how do you, do a particular heat treatment on a steel? All of those things are not really necessarily reverse engineerable. And so when they're not, why would you publish how to do it? And this has come to a head recently too, and I don't want to pick on a particular country or a particular, place, although, standards for lifting intellectual property from patents and using them liberally are different around the world. So if you publish a recipe or a process that could be a trade secret, anyone in the world can find that and start doing exactly what you're doing in their own facility. And it's very difficult to track that down sometimes because you also can't reverse engineer what they did. So you would have to get, some kind of legal permission to go into their facility and do an audit of their process. And this is a painful, expensive situation. I was recently on a trade secret case between two major Korean battery companies and was part of a hostile visit to a large Korean company. It was fascinating. They were doing everything they could to hide how their process actually was going, and they were like misdirecting the tour and burying the most important things and putting out chemicals they weren't actually using to throw us off. It was nuts. And so there's like all kinds of things like that, cloak and dagger stuff that can happen. And corporate espionage is real, and figuring out how to manage your trade secrets is key.
That reminds me, I was recently at a client site, and in order to gain access to the site, you had to sign in, right? And everything was electronic. And that is a great way to demonstrate later on that you're protecting your IP, you're protecting your trade secrets and everything you're doing within your organization. All visitors should really sign in.
Absolutely, yeah.
Okay, so it's intended to be a quick overview. So here's my sort of summary slide. Patents cover how stuff works. They have to be new, useful, and non-obvious. Trade secrets are really methods, or as Jay just said, things that give you a competitive advantage, such as a formula for, a new chemical, or, as I said, a way of tempering steel. And because I'm an IP attorney, I am obligated by the IP Attorney Code to talk about trademarks and copyrights, albeit briefly. Trademarks protect the goodwill of a brand. It really protects, in the consumer's mind, the association between a name or a logo and the goods or services that company produces. And copyrights, finally, in the context of software, it's really how you express a particular idea that's protected. So source code, for example, is subject to copyright, as is a picture or a musical composition. But I think generally we're really concerned with patents and trade secrets here. But I just wanted to give a full overview. Okay,
we're not going to spend too much time on this because I know we have a number of questions that we want to address, but I wanted to make sure that the folks on this call are starting to think about intellectual property strategy as early as possible. An intellectual IP strategy is going to be always created, a good one is always going to be created in connection with a commercialization business strategy. One, to do this right, a sound IP strategy has to be done in service to the core business goals of a particular company. It doesn't mean that there can't be IP that's ancillary to the business that is developed in-house, and we'll talk a little bit about that. But for the engineers that are focused on the actual invention and idea and innovation, it is really important that they also work in collaboration with their business team to think about how that invention enhances and can be leveraged to drive revenue to the company as it grows. And only when that business concept and business core model is understood and agreed upon, then creation, securement, and management of the IP assets begin to take shape and make sense in terms of how these things are done. Anna, you can jump to the next slide.
I got a quick question on this one for you guys, and I'll tell you, and I think the question is this. As a small company, and everyone, folks who are listening here probably are mostly in smaller or growing or founding level companies. How much annual budget should they set aside for IP? And the story behind this for me is I was doing a Series B round raise in 2011, and I was pitching to Bill Gates and Bill Gates's folks. And even though the valuation of the company was not super high, he was adamant that we budget at least $1 million a year for IP management and generation because he's fixated on IP. We did not do that. But I know there's varying opinions. And I'm just wondering, you're talking to folks who probably have very limited budgets. They don't want to spend a lot of money, and you lawyers are not cheap. So how do we balance out sort of doing the best we can versus budgeting for that and understanding how to manage, you got to pick between buying a new piece of equipment to do some really valuable innovation or, paying for paper. And do you guys have any guidance on that in terms of, this is part of the strategy, I guess, is where I'm going.
Your question illustrates exactly the importance of this commercialization strategy that I'm talking about. When you're in your early stages and you are scrapping everything together, either you're bootstrapping your company or you're in the friends and family financing ground and you don't have a robust budget for IP strategy, the business team and the inventors come together and figure out what is the critical intellectual property asset class, right? We call it a bundle of sticks that the company needs to have in order to show value. So going back to that original slide, in the very early days, it's about making sure that intellectual property that is critical to the business of the company is freed up and assigned and handed over to the company, either as an exclusive license from a university, if that's where it resided prior, or through assignment from the individual inventors. And money should be spent to make sure that that is done right for reasons that we discussed. In that initial early stage part of the life cycle of the company is when the initial conversation should be started with IP counsel about thinking about what patentability analysis, if at all, needs to be thought through to give that company what we call freedom to operate, meaning that it can operate within its domain with the intellectual property that it's looking to get, and maybe a spattering of provisional patents once that analysis is done to start creating that defensive fence in terms of both buying yourself that 1 year period to develop your IP to the point where you can submit a full-blown application, but also putting your foot on the, essentially establishing yourself as creating a formal IP portfolio. So I would say that's phase one of a company's life cycle. I would absolutely recommend, and we do this all the time when we work with companies that are moving into their Series C, Series A, Series B financing rounds, that they work with their investors on establishing a part of their budget to be dedicated to intellectual property. And I think with every financing round that occurs, IP has to be a critical part of that discussion and the budget in terms of making sure that that company is growing and its IP portfolio is growing with it. And again, it doesn't have to be patents. It can be inbound licensing, outbound licensing schemes. It can be joint development, strategic partnerships that have cross-licensing or cross-ownership or joint ownership, or even strategies for the acquisition of intellectual property from outside, or the sale of and the divestiture of IP assets that may not be core to the business model. So those conversations, investors will want to know and will ask those hard questions as part of the pitch. And Jay, to your point, some investors will actually set aside some percentage that they'll want to see spent on patent portfolios. Again, I think it depends on the industry that you're in, and which is going to drive. If you're in an industry where for you to build competitive advantage and drive maximum value for your business, which renewables, especially solar, is absolutely part of that, and batteries are part of that equation, you will want to create for yourself what we call sort of a defensive fence, meaning that an IP portfolio is going to be critical for you to create that freedom to operate within your domain, with protection from, and that monopoly that Carl talked about, from outside competitors. That is also going to be, in many cases, early stage companies all have dreams of running a sustainable, growing business for life, or exiting as part of an IPO or a public offering. The reality for startups is a classic exit strategy is acquisition or sale of the company through an asset purchase or a merger. Given that that's sort of the standard exit that we typically see, oftentimes having a robust patent portfolio can be, the sole, if not the core value proposition for a future acquisition or sale of a business. And so having that robust portfolio of patents as well informal IP can drive that value. So to answer your question, this is a long-winded way of saying it depends, which is lawyers' favorite answer to any question. But I would say that at every stage of the life cycle of an early stage company, a decision around budget, IP, priority goals are going to be critical to establish value, especially in the renewable technology space.
Yeah, I agree. I guess that the message that I think is really important to share with this audience is create a budget and stick to it, and don't put yourself in a place where you think you have to pick between investing in IP and doing the core innovation work of the company. See them as mutually beneficial and mutually dependent, and just decide I'm going to spend this much money per year or this much money after this fundraise on IP, and make sure you do that. That will allow you to, I think, be true to the investors' needs as well and understand what their tolerance and desires are. I think that's important as well.
And I know that lawyers and patent lawyers are very expensive, and folks always worry about the expense. I would say it is one of the monies that are best spent when working with lawyers. And I'm not just saying that because we have Carl, who's a patent lawyer, on this panel, but what Jay mentioned earlier is absolutely true. What you spend on a patent portfolio could have orders of magnitude value downstream that a company can recoup.
I would just add that there are ways to extend or push out your spending of a lot of money. So for example, if I know that a company doesn't have a whole lot of money initially, we'll file a provisional. And then if there's still, sort of a funding issue or a limited amount of money they can spend on the IP, then perhaps we file a PCT application, right? Because that gives you an additional 18 months before you need to enter national stage. We didn't get into this, but I guess my point is there are strategies for spreading out or delaying when you're going to spend a lot of money. And you can work with your patent attorney on that.
And I would just put a plug in for when you're looking for patent lawyers, you're looking for two things. One is subject matter expertise, that they can actually understand your business, your innovation, your inventions, and support the work that you're doing in terms of protecting the patent. But two, it's someone that actually understands and works routinely with the emerging technology space, because that kind of patent lawyer will have a sensitivity to and an understanding of the vicissitudes of a high growth company that's going through their valleys, ebbs and flows in terms of financing and resources.
So I know that we have a few minutes left. I want to make sure that we get to some of the questions. I've taken us off of share just so that we can maybe address a couple of those. Many of the questions that have come in, and by the way, there are a lot of questions, including many that were sent over before the session. I'm going to maybe share those, Carl and Justine, with you, and perhaps we can send out as a part of our follow-up a few sort of key tips that address a lot of those questions. But the good news is that many of the questions that came in, you all have proactively addressed in the presentation. A question came in from Brandon. He said that he recently watched the documentary Invalidated on Amazon Prime, and it makes the argument that if you actually have something that is really interesting, you'll likely be invalidated by the PTAB in favor of larger companies who can afford the legal proceedings, which in many cases, it sort of is to what Jay's point just was. So any thoughts on that perspective? And this session is being recorded, so we can answer the questions. I know that was another question that someone had, so I want to answer that one too.
This is, to me, I'll just start off. I don't know if you have opinions on this, Jay or Justine, but this to me is a version of, why should I try, or why should I try to get a patent if somebody like Google is going to come in and steal it because I won't be able to do anything? And my response is always, you know, what's the alternative to not try? We have a system, we have safeguards in place through the courts. The PTAB is a lot of times wrong, unfortunately. So they're kind of guessing at what the Supreme Court is going to say or what the Federal Circuit is going to say about a certain aspect of patent law. I haven't seen that yet. I do want to watch that. It's on my list. But I guess, you know, I'm more of an optimist than a pessimist. And so my advice would be to just understand all you can and do the best you can while you're still building your company. These are kind of problems that only matter if you make it, right? If you're successful. And those are, you know, from this perspective of just starting out, those are, you know, manageable problems. You deal with it then.
I remember when I started out my practice as a litigator in a large firm in Philadelphia. And one of the first cases I worked on was representing an entrepreneur who was going up against a major company where he believed that his technology was poached by that large company. This was in a TV screen technology area. And yes, there are horror stories where large companies can run a small company out of business, but having worked with large companies and small companies and sitting on both sides of the fence, the large companies are doing the exact same IP commercialization strategy discussions and internal deliberations that we're encouraging you to do, meaning that if, let's say, a Google or a large conglomerate company believes that it's easier to obtain someone else's intellectual property rather than build it in-house, they will buy you. They will give you an offer and become a strategic partner to you and acquire your technology so that it can expand its IP portfolio that way. In some respects, that's cleaner. It happens all the time. And it's a great opportunity for entrepreneurs to position themselves, to align themselves with important strategic partners that could play that buying function in the future.
Yeah, I was just going to add that when you have this situation where there's proceedings around anyone challenging the validity of your patent, the other side of this are patent trolls. There's a number of companies out there that simply aggregate intellectual property and then try to sue other people for using it, where they themselves are not going to practice the IP. They are simply trying, and they're not even trying to sue you to win in court. They're trying to get a settlement. And this, I was the target of this several times. And someone just launched a case. They found a lawyer who was willing to sue us for infringement. It was not true, but the point is that for us to hire, you know, legal counsel to fight that would have cost minimum 50 to 100K. And so, you know, the option is they sort of have you hostage, and you maybe consider offering them a smaller amount of money to just settle out and be like, whatever, we don't believe you, but the cheapest thing to do is to pay you some money, which is super aggravating. And so I've seen this happen a number of times, both in a couple of different colleagues' companies. This environment exists. And so that's another thing just to be, you know, aware of when you are the owner of a company that is making some revenue and you have specific IP. Some of these less scrupulous troll firms will come after you. And patent reform is a real situation right now in Congress and has been, you know, talked about a number of different ways. I believe this is something that should be figured out from a you know, law perspective. It shouldn't be okay to do this, but it's currently happens.
Okay, and another few questions. And again, apologies for all of the great questions that are coming in. We're not going to be able to get to all of them. I'm going to group two together. So you didn't mention purposeful public disclosure as a part of an IP strategy. How should we think about disclosure as a way to provide a competitive advantage? And an interesting sort of financial question came in. Is it proper to ask to pay attorney fees with equity?
I'll take the second one first. So some solo practitioners, patent attorneys who are on their own, will take equity in exchange for preparing patent applications. I've actually done that when I was on my own, had my own practice. I actually took equity in a company. That did not end up working out, but it could have. Larger firms, I think, are a bit more reluctant to do so. I think it's proper to ask, absolutely, in answer to the question.
There's no ethical bar to taking equity in clients, provided the analysis is done independently by the company. I will say many firms disfavor it. And then there is a professional responsibility issue for lawyers, that lawyers need to be reasonably compensated for their services. And there was a case several years back when a law firm on the West Coast was taking equity in its clients. And when the clients had a massive exit or a windfall, the money that the law firm recouped was far in excess of the legal services provided, raising a professional responsibility question related to whether that compensation was actually in fact reasonable and therefore within the bounds of professional responsibility.
Great. So what about that purposeful public disclosure part? Do we have comment on that?
Is that sort of like making it free for everybody, or, you know, everybody has it so nobody can get a patent? Is that the strategy? I'm not sure.
So Jared, I'm not sure if I can bring Jared on live to ask that question. Let me go to another question while I see if Jared can ask us that question. He's also asking, how important is it to get the claims right early on, or is it better to move fast and go back and forth with patent officers to revise claims during nationalization? While you're maybe answering that, let me see if I can get Jared on the line.
Yeah, okay. So that one is a complicated answer to a simple question. Just briefly, I would say in the United States, it matters less what your claims are initially. I mean, it's important to get your claims right? But to the extent you have to pivot, you have the ability to do so and focus on a different aspect of your disclosure, so long as there is support for it in your, by disclosure, I mean, so a patent application is, here's a description of the problem, here's the state of the art, here's what we're doing, here's a bunch of pictures that describe what we're doing, and here's our claims at the very end. That is the meats and bounds of what we own, right? So the claims can refer to different stuff within the application, but that, you know, there has to be adequate support in the application. Internationally, it's different, right? You have very little opportunity to sort of switch what your focus is in a number of countries. The EU in particular, you have a limited number of times you can go back and forth before they're said, like, let's have a, maybe it was Germany I'm thinking of. We went back and forth twice with the examiner, and then the examiner demanded that we have an in-person meeting, which was cost prohibitive for my client at the time. So I would say, in my experience, US, yeah, you can pivot a little bit. It's best to know what you want. International, there's less chance to pivot.
So I'm actually not able to get Jared right this minute. He says that he's heard that sometimes you can leverage a disclosure with existing patents to prevent others from building competing patents.
Sure, okay, so that's published to make sure nobody can own it. I don't particularly think that that is a viable strategy where you have investors who want to capitalize on the intellectual property of your company. I understand it. Honestly, I have not had a situation where a client has done that. As a patent attorney, it's sort of anathema to me. But I get it, right? So if you have some method of doing something and you're concerned that somebody else might beat you to the punch, if you publish it first, then they can't own it because it's prior art to their subsequent patent application.
All right, so I'm going to ask one last question before I ask you if there are any sort of closing thoughts, because we're right at the hour. Can I add a feature to an old expired patent to resurrect it, or is it a repatent? I have a product that the patent has expired.
If the patent has expired, you cannot add non-patentable features to it. So you can't do anything to it once it's expired, and it is treated as prior art as against your new application. Okay, so your new application would have to disclose sufficient subject matter to be new and non-obvious. And it sounds like in this situation, the non-obvious hurdle might be difficult. But again, your results may vary.
Fantastic. Are there any parting thoughts as we get to the top of the hour? Is there anything that we didn't cover that you wanted to make sure that you mentioned? And by the way, we have everyone's contact information, so we're going to send it out as a part of our follow-up so that you guys, anyone on the line, could actually get in touch with a follow-up question.
I would just say that as everyone's thinking about their IP, protection of their IP assets, don't think of it only in the context of patents, trademarks, copyrights. Think of it also in the context of contracts. I think it's incredibly important that contracts are all consistent with one another in terms of the intellectual property approach. One of the things that Carl and I, with our IP practice, we do early on with our clients is we create what we call a playbook approach, meaning that we create an approach to patents that is going to be consistently applied regardless of the commercial customer contract that the company engages in. The more consistency across licenses, across retained rights, pre-existing and background intellectual property that the company wants to withhold and own, the company can do, the more beneficial and seamless the IP portfolio from a due diligence perspective when it's time to finance or sell.
I would just, those are great comments, Justine. I would just say the core things for me are trade secret is keeping it secret. Patent is teaching the world what you're doing. Make sure that you file something before you talk about it to somebody who does not have an obligation of confidentiality to you. Those are my key takeaways.
Great. Jay, any final thoughts?
Yes, thanks. I just listen to these people. They know what they're talking about. If I knew now if I knew then what I know now when I first started my first company, I would have done things a lot differently. And a lot of the things that were talked about today are critical. And these are words that I hadn't heard. And it would have saved me time and money at the end of the day. So, you know, and the last thing I'll say is please feel free to reach out to, at least to me, and I'm sure Justine and Carl would agree, email us. We're happy to continue this dialogue or help you any way we can. Part of our job is to help educate. This is a little bit of pro bono work for us all to help this community get stronger and to grow their own entrepreneurial ventures vis-a-vis creating stronger IP and commercialization plans. So happy to offer advice. Just let me know. Thanks.
And best wishes. Congrats on, you know, having come so far, and
Agreed.
you know, you're in a really exciting time. Enjoy it.
So a special thank you today to the National Renewable Energy Laboratory and our partners at the American Made Prizes. Thank you also to Babst Calland and to Jay Whitacre with the Scott Institute. This recording will be available afterwards. We'll probably post it on YouTube, and we'll be looking at a lot of these questions that you all sent in. Thank you again for your time today, and have a good afternoon.
Thank you, Anna. Thanks all.